Well, welcome everybody, and thank you very much for joining us at this webinar on securing planning permission on grey belt sites. It's of course very timely given the guidance that was published at the end of last week, which I'm sure you all want to hear about. I'm pleased to say that we've got a multidisciplinary panel today. It's not just boring lawyers, so you'll get a variety of perspectives. As our planning expert, we've got Sebastian Tibenham, Head of Residential North at Pegasus. He's going to set the scene and discuss the grey belt definition. Then we've got a legal expert, Caroline Stairs, who's a senior associate at CMS. She's going to talk about the paragraph 155 tests and what they mean in practice. Then you've got me. I'm Katherine Barnes, a barrister at 39 Essex Chambers. I'm going to talk about the golden rules. And then we have our landscape expert, Andy Cook, who's the National Head of Environment at Pegasus. He's going to discuss the landscape evidence which is required to support a successful grey belt application. We are hoping to have some time for questions at the end. That's certainly our intention. So please do submit them via the Q&A function as the webinar progresses. And now we've got a lot to get through. So I will hand over to Sebastian.
Thanks, Katherine, and thanks for the invite. So hopefully this will work now. Just share my screen. Has that come up?
Yeah. Oh, perfect. Now you're sorted.
Yeah, has that come up for everybody? Right, great. Thank you. Right, well, jump in. Well, unless you've been under a rock, you'll know the new NPPF was issued on the 12th of December 2024, alongside the written ministerial statement and some revisions to the PPG. A key part of that in terms of the written ministerial statement was restoring and raising housing numbers considerably. So yeah, that the increase at a national level went from 300 to 370 dwellings per annum. And the graph there just shows a regional distribution. So all regions other than London saw quite a significant increase. I'm based in the Northwest in particular, so whilst the numbers aren't particularly high compared to some other regions, there was a significant increase from 21,497 to 34,678. So a 61% increase. There's a lot of people getting excited in terms of what this means, particularly in the context of those regions that are fettered by a lot of greenbelt land. And obviously a key part of this presentation today is to go through the more recent greenbelt and greybelt PPG guidance that was issued on the 27th of February 2025. I'm just going to touch on some of the key points in the NPPF first, but there's a clear expectation that standard methods are met in the context of local plans. There's transitional arrangements which you might be aware of as well in terms of how that new standard method is then applied to local plans that are already through the process. I mean, a key date to just bear in mind is the 12th of March 2025, at which point there's a number of stages depending on where you've got to and what the housing numbers are at in the local plan as to whether you can proceed. Obviously, if you're above 80% of the standard method and you're at the Regulation 19 consultation stage, then you can proceed. If you're below that 80% threshold, then there's a requirement for the council to take local plan potentially back a stage and review that and then get to examination by the 12th of June 2026 or 12th of December 2026 if they do have to go back to that Regulation 18 stage. In the context of local plans as well, paragraph 148 of the NPPF applies a sequential approach to the site selection if you're doing a greenbelt review. So that's first prioritising brownfield sites within the greenbelt, then greybelt sites, and then followed by other greenbelt locations. terms of decision making, government has scrapped the 4-year housing requirement, which the Conservatives previously brought in. Standard method applies straight away, and it's reintroduced the 5% and 20% buffers as well. There's significant changes to the exceptions to developing in the Greenbelt, which I'll touch on. And there's another key takeaway I took from it. There's a slight softening of the flood risk sequential test, but it's still applicable to all forms of flooding. But there's some clarification that in terms of if you can avoid those areas from development in terms of access, where buildings will go, and also raising levels, then the sequential assessment doesn't necessarily apply. But just if you are promoting sites, please be aware that the Environment Agency flood maps have been updated, and I think they're getting formally updated for planning purposes on the 25th of March. There is some mapping available already, so you can check your sites to see whether, in particular, I suppose, surface water flooding has caused quite a bit of issues for developments going forward. So that needs checking out, particularly in the context of Greenbelt, Greybelt promotion, because obviously flood risk is a footnote 7 issue. So there's 2 routes effectively to not being inappropriate development in the Greenbelt now. So route 1 is if you're a previously developed site, you can apply paragraph 154G. And as part of that, then there's an openness test. And then the second route is obviously if you're Greybelt, then you apply paragraph 155 tests and the paragraph 156 tests, i.e. the golden rules. And there's a Greenbelt purposes test associated with that. I'm going to focus more on the second one, but just touching on the first route to start with. This does relate to limited infilling of previously developed sites, and that can be for residential or mixed use. And the main test there is that it would not cause substantial harm to the openness of the Greenbelt. PPG, for some while now, has confirmed that openness considerations relate to spatial harm, so i.e. footprint, heights, volume, a visual harm, where you may need an LVIA or TVIA, depending on the context of your site, and then also duration and activity considerations as well, in terms of how much is the use going to intensify activity on the site, but also whether your proposal is for a temporary use, which might be a relevant consideration. In particular, we see that coming out in terms of solar farm applications where they might have a lifespan of 40 years, for instance. In terms of Greybelt land definition, for the purposes of plan making and decision making, the key points that you need to pick up are the contributions to purposes A, B, and D in paragraph 143 of the NPPF. And it must also exclude areas set out in footnote 7, but the key issue there is that they shouldn't provide a strong reason for refusing or restricting the development. So in terms of route 2, the Greybelt exception, there's a number of steps associated with it. We've split it up into kind of 4 main steps. But the first is to consider whether the site does meet the definition of Greybelt land, and in particular the purposes. Then you consider whether the footnote 7 issues apply and whether they provide a strong reason for refusal. And if you can address those 2 points, then you can be classed as Greybelt land. And then there's the appropriateness test, which applies paragraphs 155 and 156, i.e. the golden rules that I mentioned before. Other presenters will come on to those particular issues shortly. In terms of, I'm going to start with step 2 in the footnote 7 policies, but this essentially includes European national habitats, triple SIs, local green spaces, which we often find are identified in neighbourhood plans, so they need checking if you're promoting development. National landscapes, so national parks, the Broads, AONBs and heritage close. Irreplaceable habitats, so ancient woodland and veteran trees are things that you need to be looking out for. Designated heritage assets, and as I noted before, areas at risk of flooding and coastal change, and that can include all forms of flooding, including surface water. The The PPG does helpfully confirm that when you're undertaking your grey belt assessment, particularly probably for councils, I suppose, where they might be assessing a lot of different sites, that there is scope to provisionally identify sites as grey belt until further assessments are carried out that relate to these above policies. So each scheme might be able to address some of the impacts with those issues, and they might not provide a strong reason for refusal. Just going back to step one then, in terms of the purposes, most of you will be familiar with these, but if you're not, purpose A is to check unrestricted sprawl of large built-up areas. Purpose B is to prevent neighbouring towns from merging into one another. And purpose D relates to preservation and setting the special character of historic towns. And the key point is whether it would strongly, whether your greenbelt parcel strongly contributes to those particular purposes. Helpfully, the PPG confirms that villages are not applicable to any of these purposes. So if you are promoting development around a village that's in the greenbelt, you can safely say that you're not going to strongly contribute to these purposes. So in terms of council's greenbelt evidence, they can provide a useful starting point, but they typically assess different and larger development parcels or greenbelt parcels than what you might necessarily promote as part of your application. Obviously, with the PPG guidance just issued, the methodology might not be in keeping with what is now set out by the government. And from our experience, the ranking and scores can often vary quite considerably as well in terms of how different consultants undertake that. What the PPG does do is provide some level of consistency across all of these issues now. So the PPG does confirm where necessary, greenbelt assessments will need to be carried out by the council, and they should include all greenbelt land within the LPA area, identify parcels at a suitably granular level, and it confirms that a small number of large areas will not be appropriate in most cases. In particular, it helpfully points out that in certain locations, smaller parcels might be more appropriate. So, for example, around existing settlements, which may be subject to growth requirements going forward, and also public transport hubs and corridors. I think perhaps equally helpfully as well is just it standardises the rankings. So there's a strong, moderate, or weak or non contribution that should be applied. So we should start to see some consistency on all of these assessments going forward on that basis. So just in terms of the purposes, I'll just run through these quickly. The diagram I've taken is not our own. It's taken, I think, from the Bradford Greenbelt Assessment, which has been quite helpful to articulate some of the points that the PPG raises. So purpose one, to check unrestricted sprawl built-up area, a large built-up area. There's no particular definition of a large built-up area, other than it's clear that it doesn't apply to villages. A strong purpose or contribution is likely to have the following features. So it'll be a site that's free of existing development. It'll lack physical features in reasonable proximity that could restrict or contain development, adjacent to a large built-up area, obviously, and in particular results in incongruous pattern of development, i.e. an extended finger of development. So I think the key point to take away from this is if your parcel or development proposal looks a bit illogical or sprawls out, this is the key point in terms of the sprawl part of the purpose. If it looks incongruous, then there's a strong chance that you might end up with this type of contribution being afforded to your parcel. In terms of moderate, it does helpfully confirm it's still likely to be next to a large built-up area or adjacent to it. But the key difference is here really that the physical features will help contain that development. So that could be a road, a canal, could be strong woodland areas that are protected, various different features. It's not explicit in terms of what they might be, but something that helps contain development from greenbelt that might exist beyond. It can be partially enclosed, and it shouldn't result in an incongruous pattern of development. It could contain existing development on your parcel itself, or it could be subject to other urban influences, pylons, for instance, or other buildings that within the area. A weak or no contribution, so obviously if it's not adjacent to a large built-up area, then it's likely to apply a non-contribution. Equally, you could be adjacent to a large built-up area, but being contained or largely enclosed by significant existing development, which I've tried to identify on some of these visuals. In terms of purpose B, to prevent neighbouring towns from merging into one another. The PPG refers to a visual analysis in this context, rather than spatial, which I find quite interesting. So it's likely that you will need to get some landscape and visual impact analysis as part of this as well. Strong contribution. This forms a substantial part of the gap between towns, and the development would result in the loss of visual separation between the towns. It doesn't go as far as saying that it will actually merge the settlements themselves. So I think if the development will result in a significant closure of that gap, it sounds like that could still be a strong contribution. Moderate is either a small part, a small development that fits within a small gap, or it's a small development that as part of a large gap rather, or the parcel could be developed without the loss of visual separation between the towns, and that could be due to structures, natural landscape, or topography that preserve that visual separation. So that could be a large woodland belt, for instance, or just the mere fact that the towns are separated by hills, for instance, could be a strong reason why that visual separation wouldn't be lost between the two settlements. Again, it doesn't apply to villages, as set out at the outset. Weak or non, obviously locations that clearly don't sit within a gap between settlements, or it's only a small development that might affect only a very small part of the gap without contributing to that visual separation. In terms of purpose D, in terms of preserving the setting and character of historic towns, I think there's a number of assessments that probably just apply this to the likes of Chester, York, those larger cities that had greenbelt put around them in the initial instance to preserve their setting. There isn't any clarification on that. It appears that it can apply to any historic town, particularly if that historic town has a conservation area within the that relates to the setting of the town and the history of it. Strong contribution forms part of the setting of the historic town and makes a considerable contribution to the special character of the historic town. So that needs to be adjacent or significant visual importance to the historic aspects of the town. So in that context, again, you're going to have some visual analysis undertaken and probably some heritage analysis as well, just to try and fully understand what the special character of the historic town is and what those key views are to potential landmarks within it. And then moderate, again, it can still be adjacent to a historic town, but the contribution that parcel makes is either weakened by a number of factors. And that could either be because it's separated by existing development or topography. So particularly if there's been more modern development that sits around the more historic part of the town that sits between your site and that element, then you're likely to end up with a moderate contribution. It contains existing development already, or it doesn't have that important visual or physical experiential relationship with the historic aspects of the town. And then weak, which I've not put on the slide, is just that you're not next to a historic town, or in fact that experiential relationship is weakened considerably as well. Finally, I'm just going to touch on a decision that came through yesterday, so it's hot off the press. It's the first Secretary of State decision that I'm aware of that deals with grey belt. It's not a residential site, but it's one that I was involved in. It was a 15.8 hectare site for a Westmoreland motorway service area in Cheshire. It was supported by the local planning authority. The neighbouring authority, Trafford, objected, so it subsequently got called in by Michael Gove in May 2024, just before the general election. So the inquiry and the inspector's report progresses under the old NPPF, and we promoted a very special circumstances case in that instance. Ourselves and Cheshire East Council agreed that purposes A, B and D were not conflicted. So the only dispute at the inquiry was in relation to purpose C, which relates to countryside encroachment. And even then, both parties were of the view, whilst there was some impacts in this regard, there were still very special circumstances to approve the development proposal. So the inspector agreed with our evidence and confirmed actually with ours that there was only a weak limited contribution to purpose C. And the key characteristics really, as you can see on the slide there, that it was surrounded by the strategic road network. So it was an island of a site sat within the Greenbelt. So after the inquiry closed, the new NPPF came out, obviously with Greybelt policies within it. So we both, ourselves and the council, put forward separate Greybelt notes to the Secretary of State for them to consider. Cheshire East Council didn't obviously go back on the no contributions to purposes A, B and D, but they did put forward that the site wasn't in an accessible location in the context of Greenbelt policy, and therefore didn't meet a requirement within paragraph 155 in terms of accessibility. Secretary of State disagreed. Obviously, it's a motorway service area, it needs to be next to the motorway, and felt that there wasn't a conflict in this regard. And because there was no conflict with purposes A, B and D, no strong reasons to refuse against footnote 7. And in that context, we did have some heritage and flood risk issues, but we addressed those through the appeal process, and they didn't perform a strong reason to refuse. Eventually, the Secretary of State confirmed that it wasn't inappropriate development, and it was indeed a Greybelt site. That's
Sorry,
me
Seb.
done, Katherine.
Oh, right. I was going to say 1 more minute. Are you done?
I'm done. Yes, over to you.
Perfect timing. In that case, over to Caroline.
Thank you both. The NPPF states in paragraph 153 that local planning authorities must give substantial weight to any harm to the Greenbelt. Inappropriate development is by definition harmful to the Greenbelt and shouldn't be approved except in very special circumstances. Generally, development within the Greenbelt is considered inappropriate, but as Sebastian mentioned, there are a few exceptions. Oh, can you not hear me?
We can hear you. Yeah.
That looks. Perfect. So now you're on the one that says NPPF para 155 exception.
Perfect. Great. Great to start off with some IT issues. Okay, well, we haven't missed too much of my slides, to be honest. I was kind of on that one the whole time. So as I mentioned, there is a few exceptions to the inappropriate development rule. Paragraph 155 states that the development of homes, commercial or other development in the Greenbelt shouldn't be regarded as inappropriate if 4 criteria are satisfied. By satisfying the criteria outlined in paragraph 155 and accordingly not being classified as inappropriate development, you avoid the need to satisfy the very special circumstances test in paragraph 153. There is no strong reason for refusing planning permission under Greenbelt policy under paragraph 11D1 and footnote 7. And the case is instead determined under the tilted balance test in favour of sustainable development under paragraph 11D2. So this effectively shifts the presumption from one against granting planning permission to one in favour, which is obviously a significant change. Compliance with the golden rules, particularly the affordable housing requirement, and the associated viability issues with that will make it more challenging for major housing developments to benefit from this new exception. However, the exception will be especially advantageous for other types of development seeking to overcome the Greenbelt hurdle that don't have to comply with the golden rules. So what are the 4 criteria? There are 2 limbs to the first requirement. Firstly, the development would utilise Greenbelt land, and Sebastian has already run through what you need to do to demonstrate that. Secondly, the development would not fundamentally undermine the purposes taken together of the remaining greenbelt across the area of the plan. In the PPG, the government has explained that decision makers should consider whether, or the extent to which, the release or development of greenbelt land would affect the ability of all of the remaining greenbelt across the area of the plan from serving all of the 5 greenbelt purposes in a meaningful way. So this is where Purpose C, encroachment into the countryside, and Purpose E, assisting urban regeneration, come into play. Inspectors have taken different approaches in applying this requirement, and the latest guidance doesn't really provide that much more colour to what is already stated in the NPPF. However, the key points are that when you're assessing whether the site is greybelt land as part of the first limb of Criterion A, you assess the site itself against the relevant purposes. And when you're assessing the second limb of Criterion A, you consider the impact of the development on the rest of the greenbelt within the authority's area from the perspective of all 5 purposes, rather than assessing the development itself against each of the 5 purposes. I thought it would be useful if I pick out a few examples of how this has been assessed by inspectors and councils to date. So in an appeal against Tonbridge and Malling Borough Council and their refusal of an outline application for a 24-hour truck stop facility serving a motorway network, the inspector found that the site constituted greybelt land. Regarding the second limb of Criterion A, the inspector said that the loss of the site for the truck stop wouldn't undermine Purpose E, as it isn't a use which could be accommodated on derelict or other land elsewhere within the urban area. And although the development would encroach into the countryside, the area loss would be small relative to the total greenbelt, which covers nearly 3/4 of the borough. The inspector also considered the council's greenbelt study, noting that the parcel containing the site performed moderately against Purpose C. However, the site itself was only a small part of that parcel, and open undeveloped fields would still separate the development from other physical features, so the overall effect on the countryside character of the remainder parcel would be limited. Consequently, the development of the site wouldn't fundamentally undermine the purposes of the remainder of the greenbelt in the borough. Turning to council decisions, Elmbridge Borough Council originally refused planning permission against officers' advice for a mixed-use master plan comprising commercial development, a recycling facility and 40 affordable homes, on the basis that the development was inappropriate and very special circumstances didn't exist. This has been appealed, but following the updated NPPF, officers went back to committee to seek a resolution not to contest the appeal on the basis that the development satisfies the paragraph 155 test. In the committee report, the offer explained that the implementation of Criteria A will differ amongst councils depending on the scale of the whole plan area, the size of the greenbelt, and the particular shape and nature of the greenbelt. The greenbelt makes up approximately 57% of Elmbridge, and the officer considered that Criterion A would only be infringed where a site is relatively large, doesn't strongly contribute to purposes A, B, or D, but there is harm to purposes C and E to such an extent that the integrity of the whole greenbelt across the whole plan area is undermined. Here, the officer found that the development would have a moderate impact on Purpose C and no harm on Purpose E. As such, the development didn't undermine the purposes of the remaining greenbelt, and the committee resolved not to offer evidence against the greenbelt reason for refusal. Similarly, St Albans Sitting District Council, in resolving to grant planning permission for the construction of up to 500 homes in Parpendon, found that the application site only comprised approximately 0.18% of the greenbelt within the district, and due to its containment on the edge of Harpenden, would have a relatively localised impact. On that basis, it was held that it wouldn't undermine the rest of the greenbelt and complied with Criterion A. The second criterion is that there must be a demonstrable unmet need for the type of development proposed. The NPPF clarifies that for housing developments, this means that there is a lack of a 5-year housing land supply, or the housing delivery test was below 75% of the housing requirement over the previous 3 years. Similarly, for traveller sites, this is demonstrated by a lack of a 5-year supply of deliverable traveller sites. There is no specified measure for demonstrating unmet need for non-residential developments, and it will be important for developers to submit a needs assessment as part of any application to demonstrate that this requirement is met. There have been a few appeals and planning applications where a demonstrable unmet need has been demonstrated for non-housing developments. Several appeals have been granted planning permission for battery energy storage systems and solar arrays in the Greenbelt. For the needs case, the inspectors have referred to the National Policy Statement for Energy, which indicates that it may be a material consideration in TCPA applications, and highlights the crucial role of energy storage in achieving net zero and providing flexibility to the energy system, as well as the need to significantly increase solar energy production. Paragraph 161 of the NPPF also states that the planning system should support the transition to net zero by 2050, and specifically should support renewable and low carbon energy and associated infrastructure. Further, the National Electricity Transmission System Operator, NESO, provided its Clean Power 2030 Action Plan for achieving clean power by 2030, which identifies a need to deliver 23 to 27 gigawatts of battery storage and 45 to 47 gigawatts of solar power by 2050. Two projects also had a grid connection offer for the late 2020s, which would allow them to make an early contribution to achieving net zero, as often a grid connection isn't available until about mid to late 2030s at the moment. So in all of these cases, a clear unmet need was identified. Whilst there may be a national need for the type of development proposed, it will be important to show that there is also a need for it at the local level. So recently, Hertsmere Borough Council granted planning permission for one of Europe's largest data centres. The council considered various factors when assessing the need for the data centre use. A data centre development report was provided by the applicant, which highlighted the general need for data centres and assessed the suitability of the application site for providing that. In September 2024, the government designated data centres as critical national infrastructure, underscoring their importance to UK's daily operations. Additionally, the Council's 2024 South West Hertfordshire Economic Study identified a significant and growing international demand for data centres, with London being the leading location in Europe. Ultimately, the proposed data centre would significantly boost UK data centre capacity and be a part of the Hemel Hempstead London availability zone, addressing a clear unmet need. And finally, when a planning application involves multiple types of development, it is crucial to demonstrate an unmet need for each type. For instance, in an appeal concerning the erection of 57 residential dwellings, a new children's day nursery and a preschool, the developer showed that the council had only 2.89 years of deliverable housing supply. There was also a clear local demand for a nursery, evidenced by an existing nearby nursery with a waiting list and long-term uncertainty due to a rolling one-year lease. The submitted evidence and the planning obligations indicated a clear intention to replace the existing facility with the proposed nursery, ensuring its long-term operation in a new modern building with improved space. The third criterion is that the development would be in a sustainable location, with particular reference to paragraphs 110 and 115 of the NPPF. However, the NPPF does not clearly define what a sustainable location is. It doesn't, for instance, provide details on the required level of accessibility to active travel, the proximity to public transport, or the type of social infrastructure needed nearby for a development to be sustainably located. This was a point that was picked up by the House of Lords Built Environment Committee in its letter to Angela Rayner at the beginning of February. And it was hoped that the PPG would provide some much needed clarification on this, but it merely states that development on the Greenbelt land is inappropriate if it's not in a location that is or can be made sustainable, and the sustainability of a location should be assessed on local context and site or development specific considerations. Paragraphs 110 and 115 aim to mitigate significant impacts of development on the transport network in terms of capacity, congestion, and highway safety, whilst focusing development on sustainable locations by reducing the need to travel and offering a genuine choice of transport modes. The NPPF also recognises that opportunities to maximise sustainable transport solutions will differ between urban areas and rural areas. Given the subjective nature of this requirement, careful consideration will need to be given to demonstrating the sustainability of the site's location, with views from the local highway authority being crucial. A few grey bit appeals have already failed on this criterion. For example, in an appeal against St Albans City and District Council's refusal to grant permission for the erection of 4 dwellings, the inspector found that the key services such as schools, a medical centre and shops were at least a mile away. The bus service was hourly, the station was a 25-minute walk away, and the nearest road was a main distributor road. Consequently, future occupiers would likely rely on private cars to access services, leading the inspector to find that the development was in an unsustainable location. Similarly, an appeal for 6 dwellings in Tibenham Weir was dismissed due to the site's lack of sustainable location. There was no public transport connections linking the site to settlements, and while walking or cycling to access public transport was possible, the routes were either along narrow, winding, unlit roads or unpaved and unlit footpaths. So consequently, the residents would need to drive to essential services. In contrast, Basildon Borough Council recently resolved to grant outline planning permission for up to 250 homes outside Billericay. The development was in a sustainable location. It had good access to local facilities and services, and the town centre and the railway station within walking and cycling distance. Enhancements to walking, cycling and bus infrastructure, along with financial contributions, were also secured as part of the development. And in a different context, appeals concerning battery storage facilities highlighted that the aims of paragraph 110 and 115 to reduce private car use is less relevant to these developments. While there'll be some traffic during construction, it'll be minimal during the operational phase, regardless of the location of these facilities. The final requirement is that, where applicable, the proposed development must meet the golden rules requirements in paragraphs 156 and 157 of the NPPF. But this requirement can be ignored for non-housing developments and non-major housing developments, and Katherine is going to discuss these rules in more detail next. Ultimately, we are beginning to see councils feeling more empowered to grant planning permission for greenbelt development off the back of the updated NPPF, because they know that if they refuse permission, it's likely to be overturned on appeal. Thank you very much, and I'll hand over to Katherine now to talk about the golden rules.
Thank you very much, Caroline. I'm just going to share my slides. Go. So as Caroline said, I'm going to talk about the golden rules. Now, if we start with the basics, when do they apply? Well, they apply to major development, including the provision of housing on land within the Greenbelt. So important preliminary point to appreciate, it's not just Greybelt proposals. They apply to any application on Greenbelt land. But of course, compliance is particularly important when it comes to Greybelt, because of course, meeting the golden rules is required to avoid the development being inappropriate development, which, as we all know, is effectively a presumption against the grant of permission. And major development, that's actually defined in the NPPF. So for housing development, where 10 or more homes will be provided, or the site has an area of 0.5 hectares or more. Caroline, would you mind muting yourself? Because I think there's a little bit of feedback. Thanks. So let's dive in. What do the golden rules require? Well, there are 3 strands which I'm going to look at in turn. First of all, we have the affordable housing requirements, well, I've called it, there's first of all what I've called Limb 1. The affordable housing offer has to comply with development plan policies that have been produced in accordance with the new framework. So in other words, the Greenbelt specific affordable housing policies, or the alternative Limb 2, until such policies are in place, you've got to comply with the policy in paragraph 157. So that's Golden Rule 1. Golden Rule 2, necessary improvements to local or national infrastructure. And Golden Rule 3, the provision of new or improvements to existing green spaces that are accessible to the public. So let's break that down a little bit. And I'm going to start with the affordable housing aspect and the first limb. So this is where your first option to comply with this, you've got to provide affordable housing in accordance with the Greenbelt specific affordable housing policies in the development plan. Now, of course, nowhere will have that sort of policy at the moment because the NPPF is so new. And as far as I'm aware, there's not a council in the country which has yet reviewed their development plan and updated it to produce that kind of policy. But it's obviously important to look ahead, and of course it might affect a strategic decision as to when to submit an application. So what will these new policies have to look like? Well, they need to be set at a level higher than non-Greenbelt land. So if you like, that was part of the political compromise that the government made in loosening the restrictions on Greenbelt development. Okay, you can build in some circumstances in the Greenbelt, but the quid pro quo is you've got to provide a higher level of affordable housing. So they've got to be a higher level than the normal affordable housing policies and require at least, so a minimum 50% affordable, unless that would make the development of the sites unviable when tested in accordance with what the PPG says on viability. The expectation is that at least 50% will be affordable. 50% is a minimum. But I'll come back to this. Viability in future is something that can be taken into account up to a point in accordance with the PPG. So as I say, I'll come back to this, but if you've got a site where viability is a major concern, then it might actually be better for you to wait until these new policies are in place before you submit. So that's the first option, the new policies that are going to deal with this issue when local plans are reviewed. In the meantime, what is the position? If there's an application to be determined tomorrow, how would it be looked at? Well, we're looking at compliance with the tests in 157 of the NPPF. The key extracts I've set out on the slide. You've got to provide 15 percentage points above the highest existing affordable housing requirement, which would otherwise apply, subject to a cap of 50%. So this is important. At present, there's a cap of 50%, whereas it's a floor under the new policies subject to the viability point. And in the absence of an existing requirement for affordable housing, a 50% affordable housing contribution should apply by default. And then it's effectively on viability, it says, well, look to the PPG. So maybe I'll pick up the last point first. We've now got the current PPG. What does it say about viability? So this is the final point I've got on the slide there. Site-specific viability assessment should not be undertaken or taken into account. So this is in relation to paragraph 157. And it says that the government will review this and that in future there may be an exception for particularly large sites or previously developed land. So clearly somebody asked a question about this in advance, and that is the answer. At present, if you're relying on paragraph 157, there's no wriggle room in terms of viability. It's not permitted to take site-specific viability considerations into account. Again, goes back to what I said earlier. If you have got a site where, otherwise looking good, would comply with the rest of the suite of policies, but viability is a major consideration, a major concern, then in fact you may want to wait until either this expected review of the NPPG comes out, and or there are specific policies in the local plan dealing with Greenbelt affordable housing where there is some scope for viability considerations to be taken into account. And then the guidance also clarifies, I have to say, I kind of assumed that this was obvious, but nonetheless, no harm in having it clarified. It looks at how you approach this question of highest existing affordable housing requirement. So it explains the highest requirement that the local authority could seek in line with its existing policy. So, for example, if a policy is framed as up to 30%, you have to provide 30% and then plus the 15. If a policy is framed as 30% subject to viability, then again, it's 30% is your baseline plus 15, regardless of viability. So that's the correct approach to take. Now, I thought it might be helpful to just talk through a few recent decisions looking at some of these questions. And so I've set out, first of all, what seems to me a very standard example and probably what would happen in the vast majority of cases, and this is the Court Lane appeal. So it was an application for 57 dwellings and a children's day nursery. Caroline touched on it. And the proposal was originally for 40% affordable housing as per the development plan. But when the new NPPF came out, the applicant increased the offer to 50%, relying on paragraph 157 of the NPPF, and that was accepted as compliant with the first of the golden rules. So pretty straightforward example. I have to say that's how I would envisage it operating in the vast majority of cases. But a couple of sort of slightly quirky examples that I thought I would mention as well in terms of the golden rules. So first of all, the Wilton Park appeal decision. So notably likely to not be relevant to lots of cases because this was use class C2, not C3, so not standard housing. It was assisted living units and a 75-bed care home. And the development plan there didn't require any affordable housing for C2. But the local authority argued in the appeal that there should be a 50% requirement as per paragraph 157. So effectively relying on the default cap of 50% in the absence of a pre-existing requirement for affordable housing, which I have to say is, I think, what I would have understood the correct approach to be. But the inspector rejected that argument, and they found that rather than the development plan being absent in terms of an affordable housing requirement in this case, it had an affordable housing requirement of 0. And the inspector said this: the fact that the SPD did not extend the 40% requirement to use class 2 was a conscious evidence-based decision at the time it was produced, and thus itself constitutes part of the council's affordable housing policy. So in other words, it was a baseline of 0 plus 15, so 15% affordable housing was seen as golden rule compliant. Now, I have to say, query the correctness of that approach and whether it reflects the underlying policy intention of the amendments to the NPPF. I'm not sure the government would be particularly pleased to read about that reasoning, but potentially a useful appeal decision in non-standard cases that people might want to consider and draw on. And then another slightly non-standard decision, which I suspect is something that may come up more often, especially at the moment where we've got these applications that have been submitted under the previous NPPF, and then they're sort of being updated to deal with the changes. This was a decision by Basildon they resolved to grant planning permission, outline permission for up to 250 homes on a greenbelt site near Basildon. So importantly, not an appeal. This was the local authority's own decision, and indeed resolution to grant in accordance with officer advice. What happened there was that I believe it was 40% affordable housing was initially offered, but following the publication of the new NPPF, that was increased to 45%. And the officer recommended the grant of permission on that basis, ultimately accepted by members. And the reasoning was this: I've set out the key extract. While this is less than the 50% required by paragraph 157, given that the length of time that the application has been in the system for, and that the application has crossed the paths of both the 2023 and more recent 2024 versions of the NPPF, officers consider that the 45% affordable housing offer is in keeping with the ethos of the 2024 NPPF Golden Rules, which requires enhanced levels of affordable housing and is therefore acceptable. So in other words, it was found that 45% complied with the ethos of the Golden Rules, if not technically to the letter. I think that's a perfectly reasonable exercise of planning judgment, although I have to say as a lawyer, my advice would be nonetheless to acknowledge in the reasons for the decision that there is technically a breach of the Golden Rules, but nonetheless in the circumstances it's outweighed by other factors and found to be acceptable. But I do think it's important from a legal point of view to recognise the breach to reduce the risk of successful challenge. Now I'm going to whiz through the last bits because there's not nearly so much to say. Strand B, this is necessary improvements to local or national infrastructure. Now, I'd be interested, some of you may disagree with this, and if you do, please say so in the Q&A. But I do not see how this aspect of the Golden Rules adds anything meaningful to existing requirements. The bottom line is, at the moment, via SIL and via Section 106 obligations, necessary improvements to local or national infrastructure are supposed to be provided anyway. And indeed, looking at recent appeal decisions, that's how inspectors have approached the issue. It's not that additional infrastructure requirements that would otherwise that would not previously have been provided or required and now being asked for. And anyway, the Wilton Road decision is a good example of that. There's nothing in the guidance that specifically addresses this aspect. So from my point of view, it's not a material change really introduced by the new NPPF. In contrast, Strand C, so this is provision of or improvements to publicly accessible green spaces. This is a material change, albeit one that's probably easier to comply with than the affordable housing aspect. So we know green space proposals should contribute positively to the landscape setting of the development, support nature recovery. I know Andy's going to talk about that, and meet local standards for green space provision where these exist in the development plan. Where no locally specific standards exist, development proposals should meet national standards. So clearly that's going to be critical, looking at what particular authorities' studies say and what their particular requirements are in their area, which will obviously depend on the nature of the area and need and so on. A few additional points that we learn about from the guidance. The open space has to be available for public use free of charge and within limited time restrictions. It has to include the necessary infrastructure for the space to be accessed. So in other words, footpaths and bridleways. You have to consider how green space proposals will contribute to the priorities for nature recovery set out within the relevant local nature recovery strategies. So again, that's going to be very area specific. And unsurprisingly, you have to consider conditions or planning obligations as appropriate. And it also points out that SIL can be used to fund provision and improvements. Wilton Road is an example of how this was complied with. In effectively, the courtyard garden that was going to be provided as part of the development was going to be made publicly accessible. And that is a trend that you see in quite a few of these appeal decisions, which actually from the sort of, from a commercial point of view is presumably quite significant. one would have thought the value of a development will be affected by the garden space being publicly accessible, less attractive potentially to future occupants. But that case is also interesting because of the flexible approach that was taken. Effectively, a link was made with another planning provision, with another planning permission, and a section 106 was entered into, which prevented the development of the Wilton Road site until sports pitches at this other site had actually been put into place. So anyway, just a sort of quite interesting creative example as to how the requirement was dealt with there. So in conclusion, if your proposal is under 10 units of housing, you can avoid the golden rules altogether. But otherwise, I would say make the most of this golden opportunity in terms of timing. The golden rules are likely to be less onerous now, capped at 50%, than once the relevant development plan policies come forward. So a reason in most cases to get an application in sooner rather than later. And I would have also thought it will be easier to satisfy some of the requirements that Seb was talking about prior to a much more widespread release of greenbelt land in a more systemic way through the local plan process. The exception to that is sites where viability is a major concern. And as I said, that's because at the moment under 157, site-specific viability can't be taken into account. So if you're in that position, then you probably want to wait for this expected review of the NPPF, the PPG, and or local development plan policies dealing with this issue that are permitted to be a little bit more flexible in terms of viability. So I will now hand over to Andy, who is going to pick up the landscape issues.
Thank you, Katherine. And hopefully my colleague Kieran will manage my slides for me. Thank you. So I'm just mindful of time, so I will canter through my slides so you've got the benefit of seeing them and pick up the key points. But what I'd like to do is just really talk about the sort of evidence material that you require to have in place from a landscape planning perspective if you're looking to navigate your way through a green belt and grey belt scenario with regard to an application or an appeal. So next slide, please. So the first thing just to think about is paragraph 154G. The paragraph is talking about particular exceptions when it comes to inappropriateness with regard to the green belt. And one of those exceptions is subclause G, which is regarding previously developed land. And the thing I would note there is that you need to be mindful of the definition that is set out in Annex 2 of the NPPF that talks about how PDL should be regarded. And the point I would make from a landscape planning perspective is you need to be mindful of structures and how structures interact with the landscape. And the key words that are referred to are structures blending into the landscape. So that's something that you need to be particularly mindful of if you want to pursue an application with regard to PDL land in the Greenbelt. And the other thing to bear in mind is that you also need to consider the test, which is, notwithstanding the points I've just made, you need to demonstrate that the development would not cause substantial harm to the openness of the greenbelt. And so therefore that needs to be navigated too. So you need to think about the levels of harm that are likely to be derived from the development. But the key thing is to avoid substantial harm. Next slide, please. So paragraph 155, this introduces the concept of using grey belt land. And the grey belt definition is provided in Annex 2, very usefully, of the NPPF. And what is interesting is it makes reference predictably with regard to PDL, but also to other land. And where it refers to other land is referring to land that does not contribute strongly with regard to purposes A, B, and D. And we've heard reference to that in the earlier presentations. Next slide, please. So the key point here is that we need to bear in mind how the land is going to have a bearing upon the purposes A, B, and D, and to what degree it's contributing towards those purposes. Next slide, please. So the new planning guidance is very helpful because it provides some useful benchmarking and what I would describe as calibration for the understanding the degree or the extent of the land's contribution to the particular area. And it usefully has introduced what I describe as a 3-word scale of strong, moderate, or weak, / none. And if we look at purpose A, a few things I'd just like to point out with regard to purpose A. If we're looking at a scenario where the land makes a strong contribution, it's making reference to things such as the lack of physical features. And when it's referring to physical features, that's things such as tree belts, woodland, matters like that. And what we also need to keep at the back of our mind is paragraph 149 in the framework that talks about how you deal with boundaries of greenbelt and how they should be regarded. In other words, that they should be readily recognizable, that they are likely to be permanent, and they are likely to also be new greenbelt boundaries in the future. The other thing is that it refers to, in the last point there, refers to incongruous nature of development in terms of development pattern. So this goes to a landscape, townscape character point of view that needs to be considered and analysed. Next slide, please. So again, with regard to moderate contribution with regard to purpose A, and I've highlighted these points in this on this slide, is it makes reference again to physical features, and they could be things like tree belts and woodlands. I've touched on these, and in an ideal world, you would see these features being in close proximity to the land in question that would provide framework, physical and visual framework to that particular piece of land. But also it makes reference to other urbanizing influences. And again, that's something that can be picked up in any landscape character analysis, such as urban fringe and peri-urban environment. Next slide, please. So in terms of the scenario where you have a parcel of land which is considered to perform or contribute weakly with regard to purpose A, what is interesting, again, it's making reference to the degree of containment or being largely enclosed by significant existing development. So all of this can be demonstrated by means of a landscape planning report that looks at how the site sits in relation to the surrounding area, being in an age of settlement scenario. So again, relying on landscape and visual analysis to make that point. So if we turn to the next slide, this is dealing with purpose B, and with regard to the particular aspect of towns potentially merging into one another. And the reference is with regard to towns, not villages. The point I would make here is that it refers to the loss of visual separation. And what that's picking up are two points that are often discussed, particularly at inquiry, when we're talking about a coalescence scenario. And that is that you can have physical coalescence, but you can also have visual coalescence as well. So something that needs to be taken into account. And if we go to the next slide, where we're looking at a scenario with moderate contribution with regard to the land, we need to again think about how the development is going to sit in relation to the two settlements. And again, there is this emphasis on the loss of visual separation. So that's something that needs to be taken into account. This text also makes reference to natural landscape elements. And this is interesting terminology because it's terminology that's used in GLIVIA, the Guidance for Landscape and Visual Assessment. And so they may be things like, say, woodlands, tree belts, watercourses, those sorts of features, which may assist in providing a degree of separation, both physically or visually, with regard to two settlements that are relatively close to one another. And then if we turn to the next slide, which is with regard to a scenario where we have a weak contribution in terms of this purpose, again, there is this emphasis about looking at the degree of visual separation between the settlements. So this flows from undertaking an LVIA, but rather than just looking at the degree of visual effect, where that is the purpose of an LVIA, the purpose of this assessment is to look at the degree to which built form would be present or absent in terms of perception. If we can go to the next slide, this is dealing with purpose D, and with regard to the context of historic towns such as York and Oxford. It refers to the setting of historic towns, and I'm not going to stray into the terminology with regard to heritage and the concept of setting with regard to heritage assets. But from a landscape planning perspective, what I would say about setting is one needs to be aware that it has to be capable of being appreciated, and therefore there needs to be a line of sight and a visual relationship that needs to be taken into account. And that point is drawn out at the end of this slide, taken from the text in the guidance. Over the page, next slide, this deals with the moderate degree to which a particular piece of land may contribute to this purpose. And here it's referring to the land not having an important visual, physical or experiential relationship with regard to the town. So all of these things can be picked up in a landscape planning and greenbelt assessment. Over the page, again, where we're talking about the degree of contribution being weak, the same parameters are set out there. So next slide, please. When we're considering the potential impact of development on the openness of the greenbelt, well, there are a number of factors that need to be taken into account, and I'm sure many of you are very familiar with these factors. There are four: the spatial aspect, the visual aspect, the duration and remediability of the proposed development, and also regard to other elements as well. So these need to be picked up in an assessment that looks at the greenbelt and the particular type of development that is proposed. It also, one of the factors that are referenced is the degree of activity. An activity can be related and have a bearing upon tranquility. So one way of looking at activity is to look at, say, the baseline scenario with regard to the level of tranquility in the area. And for example, CPRE, tranquility mapping, may be useful as a good baseline position to consider when dealing with that particular aspect as well. Can we go to the next slide, please? So if you are looking at navigating your way through with an application and you're looking at a green belt and a grey belt situation, I would propose that a report is structured along these lines, that the introduction sets out the scope of the analysis that the report addresses, and that it then proceeds to look at how the site itself has a bearing upon the purposes A to E. Next slide, please. In terms of section 4, to look at the description of the proposed development, but from a landscape planning perspective, mindful that there is a requirement to look at enhancing and improving green spaces. And the key things to consider there are accessibility, green space standards, and nature. That should be nature recovery. The next thing to bear in mind is how the development would have a bearing upon the development of on the local landscape character. So that's a key consideration. And then from there to go on to consider how the development would have a bearing upon the greenbelt openness in terms of spatial, visual, duration, remediability and activity, which is missing from that slide there. But all of those elements need to be considered as a in the round as a basket of effects to come to an overall conclusion with regard to the overall level of harm with regard to openness. Next slide, please. So the next stage would be to look at the effect of the development on the purposes of the Greenbelt with regard to the 5 purposes. All of these ought to be considered. And then the next stage would be to look at how the development would have a bearing upon the remaining greenbelt across the area of the plan. And then obviously all these points brought together in a summary and conclusion. So just turning to the next slide, mindful of time, the guidance has made, and the NPPF at paragraph 159 has made reference to improvements to green spaces. And this is one of the golden rules. It's introduced the concept of landscape setting of the development, which unhelpfully is not set out in the Annex 2 and glossary. So I'm sure there will be some debate over that in due course. But the key point is that a number of things need to be taken into account when you're looking at improvement of green space. And if we go to the next slide, these are set out in terms of looking at accessibility, also that you need to consider the safety aspect of travel routes, the opportunity to enhance green space for nature recovery, and of course all of these things may be captured by means of condition at a later stage in an application. Turning to the next slide. One way that I've approached the aspect with regard to improvement of green space is to produce an environmental enhancement strategy that provides a positive approach to landscape design, and it sets out a number of ways in which there can be improvement to a green space in terms of enhancement of visual amenity, biodiversity, educational opportunities, as well as climate resilience and adaptation opportunities and sustainable drainage, as well as looking at recreational opportunities that are set out there. And then if we turn to the next slide, there are 3 more slides that are 3 examples, recent examples through January, February and March, where appeals have been allowed with regard to taking into account Greenbelt and Grey Belt. And these are useful in terms of how they've regarded that the developments in question have not been regarded as inappropriate development. And if you turn to the next slide, you'll see that this relates to a solar scheme. Sorry, this is a battery scheme. And the next slide refers to a solar scheme that I was involved with recently, and the decision came out. Again, the inspector concluded with regard to Burcott that it would, interestingly, so it would not now be considered inappropriate development, mindful of the guidance and the NPPF that we have in play. And that's it from me. Thank you very much for your time.
Can't hear you, Catherine. I'm not too sure why.
Sorry? Hello? Can you hear me?
Katherine, can't hear you.
Oh dear. Can you hear me now? Hello.
Yes, we've got you now.
We have you back.
Oh, right, excellent. It's now 9:45, so it's the published end. If you need to go and do your work, please do so, and thank you for joining us. We have had a lot of questions though, so I think we will stay for a further 5 minutes and try and answer as many as we can. So if you are able to stay, please do and humour us. Lots of the questions are about golden rules. So let me just begin briefly with a couple, and then I'll deal with some others and then come back to golden rules. So first of all, someone has helpfully pointed out there's an update on that Basildon decision that I referred to. Apparently just before committee, the application was updated to provide the full 50% of affordable housing. So it did actually fully comply with the golden rules. So not actually the sort of more unusual, interesting example that I had thought it might be. Very important golden rule question. I've been asked what weight would be given to a failure to comply with the golden rules. And there, I think you need to distinguish between whether your site is grey belt or not. If it is a grey belt site, then not complying with the golden rules means that you are in inappropriate development territory, which, as we all know, triggers the very special circumstances test. So in other words, not complying with the golden rules when your site is grey belt is absolutely critical and highly likely to mean that you won't get permission. For other types of site in the green belt, it's a bit more flexible. What the NPPF says is that, this is paragraph 158, a development which complies with the golden rules should be given significant weight in favour of the grant of permission. So in other words, it's a real positive in favour of permission. It's less clear about the approach where, you know, how much negative weight should be given to a breach. Still a very important factor, but something that might be outweighed by other considerations in the case of non-grey belt sites. Now, Seb, we've been asked by a couple of people if there's a definition of historic towns. Are you able to deal with that for us?
In the PPG, no, there is no further definition of what a historic town is, other than, as I said, it doesn't relate to villages. There are varying degrees of this. I did deal with a scheme down south where both myself and the council put forward that Purpose D relates to historic towns such as Chester and York, and I've seen a number of greenbelt assessments that apply that approach as well. But I've seen other greenbelt assessments undertaken on behalf of local authorities that do take into account the historic setting of other towns as well. And in fact, in relation to that appeal that I dealt with down south, the inspector there did side on the fact that the settlement, which wasn't a traditional historic town such as Chester, York or Oxford, was indeed an historic town. In that case, the appeal site was directly next to the conservation area of that historic town. But the inspector still concluded it was only a moderate contribution. They took into account factors in terms of use of the church and the conservation area and what part the site played in terms of its overall setting. So despite it being directly next to the town centre conservation area and in the green belt, it was still a moderate contribution. So I think it's probably a safer bet to assume that it might apply to all towns of an historic nature if you're progressing an appeal, is my view.
Yeah, so effectively a question of planning judgment, and of course something for heritage experts to fight about on appeal.
Correct.
Caroline, there's a question about 155B. So that's the requirement that says there's a demonstrable unmet need for the type of development proposed. And the question is whether there is a de minimis argument in that regard. So if an application is for a single house on a site that would be grey belt, but where there's a sufficient housing supply, what would be the right approach there?
Yes, so the NPPF makes it quite clear that in terms of an unmet need for housing developments, you'd need to demonstrate either a lack of a 5-year housing supply, or that the housing delivery test was below 75% for 3 years. So if you're not able to demonstrate that, you wouldn't be able to demonstrate that there's an unmet need, essentially, which means you would fail the 155B criteria. And the 155 makes it very clear that you have to satisfy all 4 requirements. So because of that, that means you wouldn't benefit from that general exception. And assuming there's no other exception you benefit from, you would have to go down the usual test of demonstrating very special circumstances for inappropriate development.
Great. Going back briefly to the golden rules, several of people have asked what happens when through a local plan review land is removed from the green belt. What then happens with the golden rules? And I mean, that's not really what this webinar has focused on. But it seems to me if actually a decision is made to remove land from the green belt, so it is no longer of green belt status, then at that point the golden rules no longer apply. Of course, the position would be different through the local plan process. One of the things that local authorities are supposed to do is identify land that is grey belt or potentially grey belt. And of course, in that scenario, it's not coming out of the green belt per se, so the golden rules would still apply. So I think that's the general principle there. Back to you, Seb. We've had also a question as to how this guidance should be read about, well, in particular, purpose A of the green belt to check the unrestricted sprawl of large built-up areas, and really the extent to which all of the features identified in their guidance have to be present, or whether you can sort of cherry pick between them. So do you have any comments to make about that and how the guidance should be approached?
Yeah, I think the point made in the question is correct. Yeah, I should have clarified, but yeah, all of those features need to apply. It does say likely to include all of the following features. So I'll correct the slide or just update it in that regard before we circulate it.
Okay. Going back to, I think this will probably be the last question on golden rules that we have time for. If you have a small scheme, so say 7 houses, so that there's no affordable housing requirement in the development plan at present, but say you're in golden rule territory because the site is over 0.5 hectares, and you're relying on the paragraph 154G exception, so that's previously developed land, so as to not be inappropriate development. Do you, in a case like that, still have to meet the golden rules? So effectively, it would be 15% affordable housing because there's no affordable housing requirement plus 15. And the answer, I think, is yes. And that was why I tried to stress at the outset that the golden rules apply to any site in the green belt that meets the definition of major development. So it's not just about grey belt. We're obviously talking about it a lot in relation to grey belt, and it's particularly important in relation to grey belt, but it applies to all green belt sites. Now, I think probably the final question that we have time for is this distinction between a village and a town. And I don't know, Andy, you've been rather left out of the questions, whether you'd like to say anything about that.
I think the starting point for when I've been doing analysis in respect to the spatial aspect and disposition of settlements is I rely on my trusty friend Google, and the first protocol is to really just try and establish from different quarters how a particular settlement is classified. Not only in terms of from the local planning perspective and what is documented in the plan, but also from a wider general perspective, a perception. So, for example, if you take Bath, it's a small place, but it's defined as a city. Yes, that's how I would approach it. And clearly there is clarity now in the guidance about that it's with specific reference with regard to towns when it's talking about the merging or otherwise of settlements,
Right.
not villages.
I think we're going to have to leave it there, not least because we've all got work that we need to go and do. But thank you very much for joining us and for sticking with us. And great thanks to all of our speakers for coming in early this morning and doing all the required preparation and giving such insightful presentations. Goodbye, everybody, and happy Thursday.
Bye. Thank you, everyone.
Thank you. Bye, everyone.